Chairman, where'd you go? Members of the committee, thank you very much.
He's listening.
Okay, my name is Lisa Iwan, and I've been a lawyer in the state of Rhode Island for over 35 years, practicing primarily in the courtroom of human drama, as we call it, the family court. Now, we all know that sometimes it takes the government years to catch up with society norms and how the society is functioning in today's world. And we all know that since the birth of the test tube baby, Louise, in England, that over the past 30 years, their families have been created across this country, across the world, through miracles of medical technology. And without laws, we've had to jury-rig and try to figure out how to get through the system. And it's been a difficult time. One of the things I want to say, I don't want to repeat everything that everybody said, but I do want to point out, at the very first point here, is for 26 years, when Chief Judge Jeremiah was sitting on the court, in 1986, when he was appointed, I went to see him because I was doing many gay and lesbian adoptions. And I did it pro bono because I thought it was unfair that gay and lesbian couples had to go through this horrific process of a 6-month waiting period, home studies, people coming in and invading their privacy, opening their kitchen cabinets, reviewing their finances, asking them about their parenting philosophies, asking them about their religious beliefs. And I said to him, Your Honor, these are two people who plan to have these children. These are the only two people who plan to have these children. They're the only two people who are going to raise these children. Would you please waive the 6-month waiting period and the home study? And for 24 years, that's what we did in the state of Rhode Island. And when he retired, Judge Bedrosian and now Judge Fort, they read the rule of the law. And until we modify our laws to reflect how we're all living in this society, creating families through artificial reproduction and through all different ways, it's going to be a big problem. Now, I know the statute is very long. When I went to see the Chief Judge Fort, he said in place, nobody's going to read a statute that's 35 pages long. I said, Your Honor, it has to be that long because we have to dot our I's and cross our T's. There's so many ways of creating children today. There's egg donation, there's sperm donation, there's creation of embryos, embryos implanted in surrogates, embryos implanted in partners. And we have to deal with all of that in the Act. And in 1973, the first Uniform Parentage Act was enacted. And 19 states adopted it. And California was one of them. The reason I'm telling you that is because an adoption hearing is a 2-part hearing. The first part is the termination of parental rights. And if you don't do that right, the second part, which is the granting of the new parenting relationship, doesn't really happen. So, California passed the Uniform Parentage Act, which part of the act says sperm donors don't have parental rights. Now, at the time, a lot of people from Rhode Island were going to the Fenway in Boston, and they were buying sperm there, licensed sperm banks. Now, every licensed sperm bank in the country, as far as I know, I've never seen anything other than that, says that sperm donors have no parental rights. Well, if you don't buy your sperm from a sperm bank that has the Uniform Parentage Act, you have to terminate the sperm donor's parental rights, which means you have to put an ad in a newspaper, which costs a lot of money. Now, this law, as everybody has already said, provides the pathways. The heart of it, it provides the pathway for stability and continuity of care for children and families. And this doesn't just involve gay and lesbian couples, because parentage is a rebuttable presumption. Now, every state in the Union, including Rhode Island, has a statute that says any child conceived in the state is deemed a child of that state. Well, we all know from Dallas and Falcon's Crest, and from our own lives, that that's not the truth, right? Oh, dynasty. I used to call it the dynasty. We all know that children are conceived not because of maybe the marital relationship. It can be the mail carrier, a friend, a neighbor. And it's a rebuttable presumption. And in fact, this is not a pun, but the seminal case on custody in the state of Rhode Island is called Pettinato. And that's the case where it determines 8 factors, which are not all-inclusive, in determining what's in the best interest of children when parents are fighting over custody of their children. And in the Pettinato case, and many other cases, what happened was A parent filed for divorce. The other parent answered and said, yeah, okay, but I'm not the parent of these children. And the family court said, what? You have fostered and condoned a parent-child relationship for all these years. Now because you're getting a divorce, you want to abdicate your parent-child relationship and walk away from that? That's not in the best interest of children. And that's in the Pettinato case and in very many other cases. And that was also in the Rubano versus DeCenzo case, which established de facto parenting in the state of Rhode Island. But with this legislation, the reality for gay and lesbian couples will change. With the Voluntary Acknowledgement Act, let me just talk a little bit about that. Today, and for the past 100 years, when a child is born, a nurse goes into the room and looks at the two parents and says, you're the mother, right? Yes. You're the father, right? Yes. Okay, sign here, notarized, names are put on birth certificate. They don't ask, are you married? They don't ask, they just ask, are you the parent? And they sign. And in fact, since the early 80s at the Department of Vital Statistics, and Sharon Santilli, sitting right over there, can talk to you about this at length, any person can walk into the Department of Vital Statistics today and sign a voluntary acknowledgement of parentage form for a child and have their name put on a birth certificate. Now, because gay and lesbian couples are in the hospital room and the nurse comes in and looks at two men or two women and says, they can't say, well, you both can't be the parent, you had to have help here. Both names can't be put on the birth certificate, even though they're legally married. But in fact, some hospitals do allow both names to be put on that birth certificate. But parentage is a rebuttable presumption. And that's what happened in Rubano versus DeCenzo. When the parties split up, the biological parent said to the non-biological parent, I don't like you anymore, I'm divorcing you, and I don't want you to have any relationship with the child. And the family court said, that's wrong. They established the de facto parenting concept in the state of Rhode Island where both parents fostered and condoned a parent-child relationship, emotionally, financially, spiritually, medically, in every aspect of life. I remember when the case came down, it was on above the crease on the Providence Journal, and I was sitting with Joe Houlihan in Newport Family Court. I don't know if anybody of you remembers Joe Houlihan, but anyway, he looked at me and goes, oh my gosh, nannies in Newport are going to be the de facto parents of many, many children. I thought that was funny, but that didn't happen. That was just a funny story. But anyway, this process for gay and lesbian couples to have to file for adoption, I want to explain a little bit about it, just briefly. So, you cannot file for adoption until the birth certificate is issued by the Department of Vital Statistics. Once that certificate is filed, then you can file for adoption. The statute requires a 6-month waiting period. That's so that the court can look at and make sure that the parents, the non-biological parent and child are psychologically bonded to one another. There's a 6-month waiting period. There are 3 home studies done either by the state of Rhode Island or by other social workers through licensed agencies. Then you have to go to court. And you have to have a hearing. It's expensive, it's time-consuming, it's terrifying. That you think that social workers might not like you or your parenting philosophies. And also, the other thing is they have to hire an attorney, someone like me, who prepares in that 6-month period that Rebecca talked about, temporary power of attorney and guardianship forms for the biological parent to sign so that the non-biological parent has standing to do something should something happen to the biological parent. It's scary. This voluntary acknowledgement form is something that's been in existence in the state of Rhode Island since, I've been practicing since 1983. Since when? Mid-80s. Since mid-80s. So it's been there since, yeah, it's 1983. And it's important to know that the only 2 people who are going to be signing that, if you look at what we put in the statute, they don't, it's much more than what you sign at the Department of Vital Statistics, which is one little piece of paper form saying, I am the father of this child, with a notary signature. The statute that we created has many more things that say in there, I plan to conceive this child, I plan to raise this child, I will be solely responsible for this child if something happens to my partner, that sort of thing. Now, I was surprised to hear that the Chief Judge Ford wrote a letter saying that he disagreed with the voluntary acknowledgement form. And he referred to the fact that it allows people who are not married to adopt, to sign this. That people who are not married should be able to do this. Now, I just want to say, I think every single one of us in this room knows people who are not married who co-parent children. You don't have to be married to co-parent children in this state or in any state. And we did hundreds, if not thousands of adoptions in the state of Rhode Island before gay and lesbian couples could marry when they had the legal impediment to marriage, when it was just a heterosexual privilege. And now that gays and lesbians can marry, I don't think that that should be a reason to prevent them from voluntarily acknowledging the fact that they want to co-parent these children. For me, this is common sense policy legislation which reflects how our society is functioning today. And when I talked to Judge Ford about this at length, I met with him for 45 minutes, and he's a guy that I know from law school. I practiced before him, had many trials before him. He calls me up sometimes and yells at me about stuff, and I call him up sometimes and yell at him about stuff. I asked him, what's your problem with this bill? And the first thing he said was, it's too long. And then I explained to him why it's too long. And then he said, I said, I don't want you to write a letter like you did last session, where you didn't like the bill, you wanted it to go to a study. He said, well, I don't think it's the job of the court to make a policy decision. That's the job of the legislature. And that's your job. It's a policy decision of the state. Should it be the policy of the state to adopt the Uniform Parentage Act? Well, since this one was rewritten in 2017, 4 states have already adopted it, including Vermont and Maine. It's pending right now in Massachusetts and Connecticut and here. I predict that within the next 3 years, this will be the law of the land. Because reproductive technology, assisted reproductive technology, is a thing that's been happening, and there have been problems as a result. And this statute commonsensically fixes it. I've been working with a group of brilliant people for the past 1.5 years to streamline this and make it work with Rhode Island law. Unfortunately, 3 of them are on vacation. One of them is the Professor Courtney Joslin, who's the University of California at Davis Law School professor, and she wrote the book on the Uniform Parentage Act. She's a national expert on this issue, and she's from Rhode Island. Her grandfather was a Supreme Court justice. Her great-grandfather was a Superior Court judge. Her dad was a lawyer who died when he was 36, very young. She clerked for Justice Lederberg. She's a person with deep roots in Rhode Island. That's how we could rope her into getting on our committee. And she actually came to make meetings because she has a sister who lives in Lincoln. And her family still lives here. We've been working with GLAAD, and there's a lawyer named Michael Grant who does lots and lots of surrogacy stuff. And there's also Kate Welton LeBlanc from Resolve. This is a very common sense piece of legislation, and I urge you to pass it. And if you have any questions, ask me. I can tell you lots of funny stories about adoption if you want to hear them.